Yes, counsel. Good morning.
Good morning, Chief Justice Ireland, and may it please the Court. My name is Robert Shaw. I'm privileged to appear today on behalf of Louis Franklin. I think it's necessary in this case for me to begin by discussing the evidence. I understand that the Court's read the briefs and has some familiarity, but there's a lot of detail, there's a lot of conflict, and I think both are relevant not only to the issues that I've raised, but also I think give rise to valid questions about how this Court should view the evidence pursuant to its 33E function, which is a large part of this case. With respect to the evidence, I do not dispute, and I cannot dispute, that Louis Franklin is burdened by evidence indicating that he sold a piece of fake crack cocaine to the victim and to some others, that there was some hostility there, that the victim was upset about that some words were exchanged. Those circumstances, generally speaking, would indicate that he is at least potentially a person who may have shot and killed the victim.
Well, as I understand it, the victim wanted his money back,
Right.
And he threatened to throw rocks or a brick through the windows of the defendant's mother's home.
Right. And there is an issue with respect to Mr. Franklin's awareness of that. But I think the important thing about the evidence here is you have those who were at the scene, the Fuqua brothers and Eric Aloyo, who saw the shooter. They were perceiving this as it unfolded, and what they described was somebody who was wearing shorts, not pants, and they described somebody who was dressed in all black, had a black hat, black gloves, and very importantly, William Fuqua testified that earlier that morning, 2.5 to 3 hours earlier, he saw this same individual dressed in black who was demanding $1,000 from somebody. Now, the Commonwealth represents that as a mistake as to time in their brief, but I would direct the Court to Volume 5, pages 160 to 165. And when you read that, you will see that that was not a mistake as to time. He saw this person at 2 points during that morning. Now, we also know that when Louis Franklin allegedly sold the piece of fake crack cocaine.
Well, wait a minute. Didn't you say he conceded he sold the crack?
Well, what I'm saying to the Court is that the evidence indicates that. Okay, he didn't concede it.
All right.
The evidence indicates that. I'm not going to try to indicate otherwise to the Court.
And in terms of the time of that sale, is that how well is that established in the record?
I don't think it's clearly established, quite frankly. But you know, this shooting happened at 10:30, and I think that it was certainly after 7:30 when William Fuqua, for example, saw this first person dressed in black demanding $1,000 from somebody. And again, the important point here is that Louis Franklin, when he allegedly sold a piece of fake crack cocaine, was said to have been wearing colorful clothing. That was Anthony Robinson. He testified that he had on a white jersey and that it had some green and a little bit of black in it and that his hat was the same. We then also know that when Louis Franklin left his mother's house to go ask Edmondson, the alcoholic who was on an alcohol binge behind the abandoned building, when he went down there to say, who came to my house, Kersha Hilliard saw him leaving the house. And Kersha Hilliard, who certainly has no love lost for Louis Franklin, testified very clearly that she had a specific memory that he was wearing a colorful shirt and that it looked like a flag. And then we have, very importantly, after the shooting, immediately after the shooting, we have both the Bell Hilliard witnesses testifying that Louis Franklin was wearing colorful clothing, including a hat that had white in it. He was jogging away from the area, from the same area that Adam Thayer said that he saw somebody coming through his yard. That is somebody that the government concedes was not the shooter. And importantly, we also have Robert Fuqua, who said that he saw a second person come up on the victim after the person in black had run, and then turned around and ran towards Mr. Thayer's yard. He thought they had red in the shirt. The Bell Hilliard witnesses saw Mr. Franklin coming from that same direction, and there are witnesses who say that he had a partially red shirt. So having reviewed that evidence, let me address 33E review. I suggest to the Court respectfully that this is not a confession case, as the Commonwealth suggests. It is primarily an identification case. It has the added element that we have Carlos Hill, who was admittedly a drug addict who was staying up 7 to 8 days without sleeping and becoming delusional, smoking crack cocaine, who 3.5 years after this happened was arrested and decided admittedly that he would try to help himself, and told the police, contrary to what he had told them previously, that Louis Franklin told him the information that he had.
Could I just stop you there? I'm a little confused. I gather that he testified before the grand jury twice.
Right.
And the first time he said something different than at the second grand jury hearing, and yet at trial he testified consistently with his first grand jury testimony?
That's correct. So what happens is he testifies at the first one. He generally says that he learned this from people in the community. A lot of people were talking about it. Obviously, also his aunt, Wanda Franklin, knew the story because Kershaw Hilliard had told her that this, the victim had gave the story to Kershaw Hilliard when he was threatening the home. So this was all common knowledge. Then 3.5 years later, he's arrested, obviously. He's going to get sent to jail. He's probably going to go into withdrawals. He's trying to help himself. He decides to say, oh, I learned that from Louis Franklin. Then, after his situation is resolved, he testifies at trial, and he retracts what he said. So is what he said in the second grand jury in evidence? It is. But is it the weakest kind of evidence? I suggest it is the weakest kind of evidence. My suggestion to the court when looking at this through doing its 33E function is that when you have direct evidence, you have people who are perceiving these events as they unfolded, that they're providing a description that is inconsistent with the description of Louis Franklin that morning, both before and after, that this is not a tangential inconsistency in this case. It is not a small inconsistency. And it becomes much more troubling when you account for the fact that Mr. Thayer saw someone coming through the yard, which is, consistent with the second person that Robert Fuqua saw, which is consistent with Louis Franklin as seen by the Bell Hilliard witnesses. Now, I also want to address the Commonwealth's version of 33E review, because the Commonwealth presents in...
Before you leave the facts, I'm just trying to get a sense of what your alternative understanding would be based on the evidence. So, I mean, certainly he has a strong motive. He appears to be very upset with the victim for having come to his home. He says certain things to indicate that at least somebody came to his home, and he's angry about that. And then shortly thereafter, this fellow gets shot.
Right.
And then you have a lot of folks running around.
Right.
But I don't quite know what the is there any alternative to the fact that he shot him? Was there any evidence of other things going on with Mr. Falcone, with other persons in the neighborhood?
Well, we know he's sort of wandering around the neighborhood. He's apparently looking for drugs. It's a very rough area. A witness testified that the gunshots commonly heard and doesn't even make him blink. We have another individual that was apparently seen by William Fuqua. We have Ernest Ogletree, who's out there. I think the court can infer that something's going on that street. I think this is a drug area. There's a lot of people coming in and a lot of people leaving. And I think the court can look at Ernest Ogletree and what he's doing. He happened to have been walking up from Main Street at the time that the shooting happened, according to Nina Hall. So, there are a lot of people around. Can I tell you exactly what happened? No. I can't. But going back to the 33E review,
Well, isn't your theory, though, that the man in black did the shooting?
Oh, absolutely.
Yes.
Absolutely.
And because the defendant was wearing colorful clothing, he didn't do the shooting.
That's right. He was in the area, but he did not do the shooting. And, you have 8 witnesses who are testifying as to clothing and giving some form of identification, and you have 7 of those 8 witnesses who are really providing information that is in some sense exculpatory, that is contradicting the Commonwealth's theory by describing Mr. Franklin with colorful clothing. Now, that's why 33E is so important. The Commonwealth provides a very restrictive view of 33E review. I mean, it really could be equated with a legal sufficiency analysis. And I suggest to the Court that that simply isn't correct. It isn't correct to say that if there's any evidence, it's not this Court's province. You know, this Court's obligatory review is very broad. It does, in fact, involve looking at the weight of the evidence or evaluating the thrust of the evidence, as this Court recently said in the Colleran case. And cases going back decades has this Court looking and saying that we don't find any reversible error, but we think we should reduce it, or, you know, we don't think that the weight of the evidence is strong enough. There are many, many cases in that area. Now, is it also true that the Court has from time to time used language that is simply too restrictive? And the answer to that is yes, and the Court has acknowledged that in its own opinions. I believe it was the Tavares case where the Court indicated that. Now, the Commonwealth has relied on the Du Bois case, which was a 2008 case. And I think that's an example of using language that's too restrictive. The Du Bois case cites the Nardone case, which is not a 33E case at all, using language that concerned a directed verdict. And then there are two additional cases there that also concerned a directed verdict. So I just point that out because I think it's important. I think that it's an interesting area of law because there are from time to time these inconsistent versions of what this Court's responsibility is and its power. Now, with respect to the prosecutor's closing argument, the first issue incorporates the first issue in my brief and concerns the prosecutor asserting that this was a premeditated killing, and the proof of that is the fact that Louis Franklin was aware that the victim had made threats against his house. And this issue is admittedly a very narrow one. The Commonwealth asserts that there is evidence of general hostility, and that's enough, and that there's also Carlos Hill's statement that Mr. Franklin said he knew this. Of course, he could have learned that after the fact, most certainly, but the point here is that when you look at the witnesses and their testimony, again, as this unfolded, it's very clear that Mr. Franklin did not know, for example, what this victim said to Kershaw Hilliard about the house. So the question really becomes, even if this Court says, well, we think the evidence is sufficient based on Carlos Hill's statement that an inference could be drawn that Mr. Franklin knew about these threats against the house, the next question becomes, well, why does that permit statements from the victim to Kershaw Hilliard, which were far more extensive? Why would it permit statements from the victim to Edmondson, the drunken homeless Edmondson, who was behind the abandoned building to drink?
Wasn't
when
there
he
some
wasn't
testimony that the victim had spoken with Robinson by telephone, and that that the defendant spoke with Robinson by telephone and said, "Where's the white boy?"
Yes.
So.
But there's no doubt that Mr. Franklin had an interaction.
And that he knew that the buyer, the victim, was unhappy.
Oh, he knew that. Yes, I mean, that's clear. He knew that. But, Your Honor, I think the point is when somebody then makes specific threats to destroy somebody's house by any means necessary, it's an escalation.
Right. I mean, could there be any argument made that also there was the neighbor who had heard loud voices before the shooting to the effect of, "You come to my house being disrespectful"?
That was what Nina Hall said. Yeah.
That's closer.
It is closer. It is closer. If you know, it is closer, and it is in evidence. I mean, it's completely contrary to what Ogletree said. It's completely contrary to what the Fuqua brothers said. But it is in evidence. But the point also being that it's not saying you threatened to destroy my mother's house. So again, it's this escalation about a specific threat, and that's really what the issue involves. This issue was argued by trial counsel. It was preserved, and I certainly think it's a viable issue for the Court to determine here. We also have Mr. Thayer's comment during closing argument that I'm sorry, the prosecutor's comment during closing argument that Mr. Thayer was the only person who mentioned a white hat or the color white with a hat. That was a significant misstatement, and it was a significant misstatement because the Commonwealth conceded that this individual coming through Mr. Thayer's yard was not the shooter. And then we also have the consciousness of guilt issue, where the prosecutor agreed that there was no basis for a consciousness of guilt instruction. The defense counsel gave his closing argument and didn't address it, of course, and then the prosecutor argued consciousness of guilt.
Does it matter that is the prosecutor precluded from arguing it just because the judge doesn't give an instruction about it?
Well, I think the implication of the discussion is that there wasn't a basis for that argument, that there wasn't evidence concerning consciousness of guilt that was satisfactory.
But there was evidence that the defendant had gone to Florida.
His father lived in Florida.
That's right. There might be other explanations for it, but that the jury would have heard that he'd gone to Florida. And wouldn't they also have heard the grand jury testimony of the cousin saying that that the defendant had told him he went to Florida because of the shooting?
They would. But the point...
There was not that there wasn't basis in the evidence for the prosecutor to argue the significance of flight.
I think that he probably would have been justified in doing so, but he agreed that there was no justification. I mean, the point of the instruction is to guide the jury, certainly to say that, you can't convict on this evidence alone. Certainly, the defense counsel should have been aware of it so that he could argue it and rebut it, because there was a way to rebut it. And yet he didn't do that because the prosecutor had agreed. I think once the prosecutor makes that commitment, he shouldn't have been making the argument. And I think it was prejudicial for that reason.
Was there an objection to it?
There wasn't an objection. Now, clearly he could have objected, but I mean, one can understand why, and the case law acknowledges this, why he would not have requested an instruction at that point. Why bring more attention to it when he hasn't had the chance to address it at all? And that could have been his thinking, or he could have simply neglected.
Now, going back to the prosecutor's closing with regard to his description of who came to my house, I gather he said something other than that. The prosecutor quoted it differently?
Right. The prosecutor did make some misstatements as well concerning, he said that he was throwing rocks. I think he actually said that the victim threw rocks at the house. Is that what you're referring to?
I don't know. I thought there was a question of, I gathered the evidence was that he said who came to my house.
Exactly.
And the prosecutor, I thought, rephrased that.
I think he did rephrase it, and he also made a misstatement and asserted that rocks were actually thrown at the house, which again would have been a further escalation.
And no objection there, I gather.
No objection. Finally, we have the identification instruction issue. And again, I want to emphasize that I think on balance, the identification evidence was really exculpatory. 7 of 8 witnesses providing information.
But none of the witnesses identified the defendant, right?
Well,
they just identified people in different color clothing.
That's correct. But the reason that the identification issue is an issue is that you do have Erica Luyo, who is identifying 2 people out of an array, one of whom is Mr. Franklin. This is evidence that was relied upon in the prosecutor's closing argument. And certainly that's him, but it is persuasive, and it was relied upon by the government, and it could have tipped the scale. And you also have Edmondson, who says that he thought he saw Mr. Franklin's head running by. Again, that was relied upon by the prosecutor in closing argument. And the point here is that the jury had no information about the purpose of identification evidence, no guidance with respect to how to evaluate it. Now, the Commonwealth says that credibility instruction was enough. Well, if you accept that a credibility instruction is enough, then you might as well determine that an identification instruction is just superfluous in our jurisprudence. Certainly that's not the case. And this court, in the Rodriguez case, in a similar manner as the Pennsylvania Supreme Court, has said that when there is some uncertainty or some ambiguity, as there was here, especially with Luyo picking 2 people out of 6 instead of 1, that it's more important to have an identification instruction in those circumstances.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honors, what you've heard to a large degree from my brother counsel here is his view of the evidence and how he thinks the jury should have regarded issues of credibility or weighing of the evidence. That, of course, is not what this case turns upon, and in fact is not what the court should be concerned primarily about in terms of its 33E authority. Your Honor, there was ample evidence of guilt here. All the jury needed to do was to believe the well-corroborated statements of the defendant given to his cousin Carlos Hill.
Does your case turn on Carlos Hill?
Not entirely, Your Honor, no, but that is there, and I'm suggesting that the evidence, that is an easy way for the jury to arrive at their verdict, and it amply supports the verdict, is what I'm saying, Your Honor. And, as an aside, I don't believe there's anything in the record as to what Carlos Hill first told the grand jury. I don't think there's any indication that he said that he had heard somewhere some kind of hearsay that his cousin may have shot the victim. I think he was entirely not forthcoming at all in the first grand jury thing. The second grand jury is when he testified that his cousin had in fact told him that he did this sale of fake drugs to the victim. That was corroborated by the other two people involved in the purchase. He told him that the victim had come by his house threatening to throw rocks, and that was corroborated by the testimony that he had been there threatening to throw rocks. It was testified.
But by the same witness who recanted at trial, right?
No, Your Honor, it's testified by the fact. The fact of the threat was shown by the woman who lived at the mother's house.
Fact of the threat, but, I mean, the knowledge of the threat.
The knowledge of the threat comes from Carlos Hill. It also comes from the accusation and the accusation that the defendant made to the victim when he went up to him and in an accusatory, confrontational fashion said, "Who came by my house?" After he'd been looking for the victim. They had a later argument there that went on about it, and he left saying, "I'm not going to take it."
Slow down for a second. All right. Who came by my house? Now, who's the witness to that? Who testified that this conversation took place?
Edmondson, Your Honor.
Okay. All right. Then what happened?
And then there's the evidence that at the time of the shooting, the voices outside were talking about a theft of what they came out of $15. You could easily, jury could easily infer it was the reference to the $14 theft. And a reference to "you came by my house" being disrespectful. This is evidence that would amply, independent of Carlos Hill, amply support the conclusion that
This evidence comes from someone who didn't identify the defendant, but heard this conversation?
yes, Your Honor.
Okay. And what did the witness then say about what she observed? She heard this conversation.
She heard the conversation. She didn't identify the defendant. She heard the conversation. She heard the shots. I'm right this second not
Well, I can't
remembering whether that was Luyo, who's the witness who made the photographic who went through the array and made a tentative a selection of two different photographs, Your Honor.
That was not the same person who said this business about you.
All
came
right,
by my
Your
husband.
Honor, I'm not trying to say this. I'm not sure is what I'm saying.
Okay. Because I thought that wasn't it Nadine or somebody who did the "you came by my house" being disrespectful? Maybe not.
I'm not sure of the names right now, Your Honor. I'm sorry. But, Your Honor, I'd suggest that that's easily within the realm of the cases of both Sharp at 454 Mass 135 and Purcell at 423 Mass 880, where a jury could infer that the defendant was aware of the defendant's threats in this
I
situation.
don't think it's a sufficiency question. I think it's largely a 33E question, given the fact that this is a case based entirely, almost entirely on evidence of motive, ambiguous identification, and a recanted statement attributing certain information to the defendant.
Which makes it very critical that at the immediately before the shooting, you have references from the people who, by all indication, are involved in the shooting, references to a theft of the $15 and a accusation of you came by my house being disrespectful. A jury could readily infer that that's a reference back to this situation that had been going on between the victim and the defendant earlier that same morning, Your Honor. Whether or not that person saw them. The circumstantial evidence, it is indeed primarily a circumstantial case, and there's no question about that. It is not a case that is particularly dependent on positive eyewitness identification of the shooter. It's not that at all. The only person who said clearly that they saw the person during the shooting was totally equivocal in her testimony about whether she was sure who she picked out. One of the pictures she picked out was, in fact, of the defendant, but she was clear that she was not making a positive identification, Your Honor. Which is why, in this particular case, there was no particular need for an identification instruction, a focus on identification instruction, because there was nothing critically turned on identification evidence of that sort. Counsel here was offered the opportunity to consider whether he wanted an identification instruction, and he declined to make that request.
I'm sorry, he declined to make the request, or he simply did not make the request?
He did not make the request. And we infer, Your Honor, we presume that counsel knows what they're doing. And here, by not making the request, is in effect inferably a choice not to make that request. And there's a reason, it was a manifestly reasonable choice where the classic instruction would tend to say that an identification made out of a group such as an array would tend to be more reliable than others, that would tend to enhance Ms. Luyo's credibility in making her tentative identification. It could easily be viewed as harming the defense. Another part of the classic instruction would say that an identification made by someone who already knows the person may be more reliable. That could tend to enhance Mr. Edmondson's identification of the defendant running behind him near the victim shortly before the time of the shooting, Your Honor. So cannot show here that there was a substantial risk of a miscarriage of justice or a substantial likelihood by the lack of an identification instruction. Your Honor.
So, going back to Hill, were any promises, rewards, or inducements given to Hill?
Your Honor, I know my brother has suggested that. I don't remember that there was any evidence of any of that being done at all in this situation, Your Honor. But
So was there an instruction given that his testimony should be viewed with caution, which is what's generally given when somebody receives rewards, promises, or inducements?
which I don't remember that being given. I don't remember that coming up. It's been a while since I'm not trying to excuse myself, but I don't remember that. I don't believe there was evidence of that he had in fact been given any kind of rewards or inducements. I would, of course, defer to the transcript, and I'm not saying I positively remember that, Your Honor. At trial, well, no.
Return to the closing argument.
Sure, Your Honor. And there was what the testimony was that after the defendant had called up Robinson and said, where the hell's that white guy, in so many words, and wanted to go, and he's down by the house. And after he went down by the house and went right up to the victim and said, who came by my house, in what was described as an angry, accusatory manner, then the prosecutor, it was who came by my house is what the testimony was. The prosecutor characterized it as you came by my house. It was not presented as an attempted quote of the testimony. It was a characterization of the testimony, and it was a readily inferable one, that this was not a simple sort of innocent request for information. It was an accusation, Your Honor, and it was an accusation that was fairly interpretable as you came by my house, and so then that was reasonable, proper argument, and did not present any kind of substantial likelihood of a miscarriage of justice when it was readily inferable for the jury in any event. The hat question, there was one witness, it was Adam Thayer, who described the hat as a light-colored, like white hat. He's the only witness that described it as an overall whitish hat. The other testimony raised by my brother was that it was a black and green hat with maybe a little white, or a Celtics hat, which was green, white, and black. That was by Imani Bill Hilliard. Her brother, who saw the same person, described it as a green hat. The only witness, as the prosecutor suggested, who described anything that could be fairly characterized as an overall whitish hat was indeed Adam Thayer. And I don't, again, that's a reasonable inference on the record, and I don't think there's anything improper about the argument. On the consciousness of guilt, the prosecutor did not, in fact, ask the jury to draw any consciousness of guilt inference from the trip to Florida. What he was saying was he was supporting the credibility of Carlos Hill's second grand jury testimony and saying doesn't it make more sense in this situation that he would go to Florida because of the shooting? Isn't that more credible than what he's told you in the stand here today? It was not presented as a consciousness of guilt. It was not taken that way. There was no objection on that. There was no instruction. What happened here then, insofar as the jury was ever going to hold that particular piece of evidence against the defendant as a possible consciousness of guilt, it was then left for them to assess, which is entirely permissible, Your Honor, as this court said in Commonwealth versus Irene, which is at 462 Mass 600. Your Honors, this court does not sit as a second jury. It is not this court's role to sit and decide credibility and weight issues entirely independently without deference to the jury. The court is clear in the law that it's been clear throughout history that it does not sit as a second juror independently to decide questions of reasonable doubt. Here, the jury's conclusion is supported by rational and reasonable views of the evidence, and it should be affirmed, Your Honor.
Well, let me stop you there and to take up Mr. Shaw's point. Certainly, we evaluate sufficiency.
Yes, Your Honor.
Are you saying that 33E is no more than sufficiency?
No, Your Honor. I'm saying that clearly under 33E, there is a level of deference in this court that goes beyond most situations that allows for an evaluation of the overall weight of the evidence. That does not equal a free-riding, new independent analysis that allows the court simply to arrive at its own, or each justice to arrive at their own individual assessments of credibility without having the opportunities to see the witness, to evaluate them as they're on the stand, or any of that. What I'm saying is, yes, the court has authority to view the weight of the evidence, but it does not, is inappropriate to simply decide that this court would have reached a different conclusion on arguable weight of the evidence issues. And if it's, unless it's reached some kind of point to be concerned that there has been truly a basis for a miscarriage of justice of this sort, then the jury's determination is entitled to substantial deference in this and every other case, Your Honor.
Thank you, counsel.
Is there anything else?
Thank you.